This is the appointed time, and we have a quorum. So I call to order the meeting of the panel on administration of justice and legal services. Item 1. Information paper issued since the last meeting. The Secretariat has not issued any information paper since the last meeting. Item 2. Items for discussion at the next meeting. Please refer to LC paper number CB-3/2026-01, which is the list of outstanding items for discussion. The next regular meeting is scheduled for the 27th of April, 4:30. We're going to discuss the following items. First, updates on the provision of legal aid services by the Legal Aid Department. The Department of Justice will submit a proposal. So 2 items will be discussed at the next meeting. Let's see if there are views. If not, we move on to the 3rd item on the agenda, which is the proposal to amend the Evidence Ordinance, or Cap 8. Let me invite the administration to come in, as well as representatives of the Law Society of Hong Kong and Hong Kong Bar Association. Members should have received the relevant papers, which are already uploaded onto the website, including CB-3/195/2026/02, 03, and 04. Let me welcome Acting Secretary for Justice, Dr. Horace Cheung, Mr. Llewellyn Mui, Solicitor General, Department of Justice, Mr. Jonathan Mann, Deputy Director of Public Prosecutions, also from the Department of Justice, and their team. And let me also welcome Mr. Stephen Hong, past President and Chairman of the Criminal Law and Procedure Committee, the Law Society of Hong Kong, as well as Ms. Kelly Lam, Deputy Secretary General and Director of Practitioners Affairs, Law Society, and Ms. Vincy Lam, representing the Bar Association. Thank you. Well, we will discuss this item until 5:30. So members, if you want to ask questions, please press the button. So I'll give the floor to Dr. Horace Cheung, Acting Secretary for Justice, to walk us through the paper. Chair, members. The purpose of the proposed Evidence Amendment Bill 2026, or the 2026 bill, seeks to implement the recommendations of the Law Reform Commission in order to reform the rule against hearsay evidence. Now, for hearsay evidence, it refers to the testimony given by somebody other than those involved in the court as admissible evidence. Under the common law, unless the evidence falls within one of the common law or statutory exceptions to the rule, called the hearsay rule, generally, hearsay evidence is inadmissible in criminal proceedings and will not be accepted by the courts. This rule seeks to ensure justice and fair trial so that the witnesses' evidence can be examined and cross-examined in order to enhance credibility and accuracy. However, over the years there have been widespread criticisms on the hearsay rule, including the lack of flexibility, the rule being too strict, and also ambiguity. Despite cogent and reliable evidence, if it is hearsay evidence, then there will be a broad brush approach of not admitting this evidence, and this will sometimes affect justice in the courts. Now, for example, for vulnerable witnesses involving, say, children and persons with mental incapacity, or victims who are severely traumatized because of their physical and mental conditions, despite having had an interview with the police and made the statement because of their circumstances, their evidence would become hearsay and hence inadmissible in criminal proceedings. This is in fact not unique in Hong Kong. In fact, after learning from the reform experience of other common law jurisdictions, we proposed systemic reform proposal in 2009. And to implement this proposal, the administration once tabled the 2018 bill to the Legislative Council. But the bill lapsed because of insufficient time in the Council to deal with this bill. The Department of Justice then proceeded to a comprehensive review, taking into account the LRC's recommendations, as well as comments received during the consultation exercise in 2017, the deliberations of the Bills Committee on the 2018 bill, as well as the latest legal and policy developments. And as such, we have come to the 2026 bill. The 2026 bill preserves the core of the 2018 bill. As far as the legal framework is concerned, apart from preserving the common law exclusionary rule as well as statutory exceptions, hearsay evidence may be admissible in court if these conditions are met. First, by agreement, either in written form or orally, of the parties to admit hearsay evidence. Two, for the party intending to adduce hearsay evidence to give notice which is unopposed by the other party or other parties. Number three, following a hearsay evidence notice given, another party makes an objection, and then eventually the court grants permission to the admission of hearsay evidence. And in order for the court to grant such a permission, 5 conditions must be met. First, the declarant is sufficiently identified. Second, if the person is allowed to, is able to give evidence in court, the evidence should be admissible in court. Third, the condition of necessity is fulfilled. That is, the declarant is dead, for example, not fit to be a witness because of the physical or mental condition, and the applicant has the burden of proof. For the prosecution, a higher standard of proving beyond reasonable doubt is required. As for the accused, in order to prove necessity, he needs to prove on the balance of probability. Fourthly, the condition of threshold reliability should be met. Different factors will be considered, such as the nature and content of the statement, the circumstances in which the statement was made, and the truthfulness and accuracy, etc., to ensure that hearsay evidence will have a reasonable assurance of reliability. Fifthly, the probative value of the hearsay evidence is greater than any prejudicial effect it may have on any party to the proceedings. Comparing to the 2018 bill, there is a refined approach to further improve the proposal. For example, courts will be given a wider margin to exercise discretionary power, so it's more flexible. The bill empowers the court to exercise discretion to vary the procedural requirements in light of the circumstances, so that ad hoc situations can be handled more effectively. The exclusionary mechanism is also refined. In the 2018 bill, a rather rigid approach is adopted. That is, as long as the court finds the conviction to be unsafe, then the court must acquit the defendant. Now, there is a restriction as far as the law is concerned. Even if the burden of proof has been discharged and the threshold is met, the jury is still unable to take part in the decision process because of this hurdle. This is a broad brush approach. In the 2026 bill, we've refined the approach. Even if prima facie the court accepts hearsay evidence during the trial, upon application by either party and in the interest of justice, the evidence can still be excluded, and that remedial action can be taken by the court. For example, the court may direct the jury not to give weight to the hearsay evidence or order a further trial, or if there is no case or no longer a case against the accused after exclusion of the evidence, direct an acquittal. This approach respects the fundamental separation of roles between the judge and jury and provides a better safeguard against prejudice. The third feature is that it excludes national security cases. In the 2026 bill, it stipulates that it should not apply to national security proceedings. The common law rule against hearsay evidence continues to apply to national security cases to prevent or to mitigate risks from manipulated or disinformation-based evidence. On consultation in December last year, the Department of Justice issued a consultation paper together with the consultation draft of 2026 bill to collect views from stakeholders. We consulted the judiciary, the two legal professional bodies, the relevant policy bureaus and departments, law schools in universities, as well as other relevant organizations. We are happy to learn that the overall response has been supportive. Stakeholders are of the view that the new bill could help courts in seeking truth and justice. I want to emphasize, lastly, that it is necessary to reform the hearsay rule. The 2026 bill provides sufficient safeguards on the fairness of trial. It also allows courts to seek the truth, so that our criminal law and criminal procedures are highly aligned with other common law jurisdictions around the world. The Department of Justice will continue to take forward the legislative task, and we will carefully consider the response given by stakeholders as well as views of members today, so as to complete the drafting of this bill as quickly as possible, with a view to tabling this bill into the Legislative Council in the second quarter of this year. Thank you. Thank you, Acting Secretary for Justice. Let me now invite Ms. Kelly Lam, Deputy Secretary General, or Ms. Vincy Lam, Committee on Criminal Law and Procedure, Chairman, Hong Kong Bar Association, to deliver the speech. You have about 5 minutes. Thank you, Chair members. The Hong Kong Bar Association already provided a written response to the Department of Justice in February in relation to the bill. On the whole, the Hong Kong Bar Association does not object to the revision to the hearsay rule in criminal cases. However, we are of the view that greater clarity can be put in place through this legislative amendment exercise to ensure fairness. Our core concern is not that hearsay evidence should remain inadmissible in general. In some circumstances, hearsay evidence should be accepted in our view, but we're concerned that the fundamental principles on hearsay rule should still apply. That is, reliability of the evidence, and that either party should have the chance to examine and cross-examine the relevant witnesses, and that procedural fairness should be ensured. In a criminal trial, cross-examination is necessary in testing the evidence, is important in preventing wrongful conviction, and it is a major safeguard. Now, on this issue, the Bar Association supports striking a balance. We support modernizing our laws, and there is a need to set up a clear system. We also support empowering courts to exercise discretion. In order to meet the above objectives, we believe there is room for improvement for this bill, so that whilst ensuring flexibility, we can also strike a balance between flexibility and meeting constitutional requirement and ensuring fair trial. I'm going to highlight a few comments from our association. First, on the scope of application of this bill, greater clarity should be provided. We are of the view that the bill should clarify the overall arrangements in criminal proceedings. For specified evidence, at the moment, it refers to hearsay evidence submitted by the prosecution as an aggravating factor, but it doesn't spell out details about hearsay evidence submitted by the defense for the purpose of mitigation. If the new framework applies to hearsay evidence for mitigation to be submitted by the defense, we believe that this should be spelled out with greater clarity. Now, if the new mechanism does not apply to hearsay evidence to be submitted by defense for mitigation, then the administration should provide justification and explain whether the defense will still be able to submit such evidence. Otherwise, in terms of sentencing, there will be uncertainties. The Bar Association is happy to learn from the DOJ's response that they will give some careful thoughts to this suggestion. Second, in relation to the procedures in the admission of hearsay evidence, Bar Association is of the view that safeguards should be put in place. We're concerned about 55I, that is, admitting hearsay evidence by oral agreement, including litigants in person. Our association believes that apparently risks will stem from such an arrangement because litigants in person may not fully appreciate the meaning of hearsay evidence and the agreement for such evidence to be adduced, as well as the consequence of admitting such evidence. We are of the view that under all circumstances, clear guidance should be provided as to the recording of oral agreement. Ideally, written records of any oral agreement should be kept, especially in the case of litigants in person. The third comment is that the court must exercise the discretion very carefully in admitting hearsay evidence. The current standard is that there should not be any precedential effect on either party because the defense is not required to prove its innocence, and this should be reflected in the bill. On reliability, we are concerned that it only requires a reasonable assurance of reliability of hearsay evidence, and it is not cogent enough. So much from me.
All right. I will now ask Mr. Stephen Hong, past president and chairperson of Criminal Law and Procedure Committee of the Law Society of Hong Kong, to speak. Thank you, Chair. Good afternoon, members. Let me adopt first what Ms. Finzi Lam SC said earlier. I fully agree with her. Due to time constraints, I will not comment on each and every section to be amended. I hope members, when you scrutinize the bill, you have to consider the fact that in future, if this law is passed, hearsay evidence will be regarded as true evidence. The point is, the defense cannot challenge the reliability of the evidence proposed by the witness. The Law Society observed the DOJ has made some changes, but then this is a significant issue. The defendant does not have a chance to examine the witness, and to a certain extent, the defense has to disclose the line of defense of the defendant. The DOJ said the relevant rule applies to alibi as well. But then, even if the defense gave an alibi notice, the prosecution would have to investigate. But this does not apply to hearsay evidence. There is really no way to verify genuine unavailability. Secondly, none of the amendments mention whether the prosecution has to tell the defense why a witness is unavailable. Maybe a witness is afraid. Maybe in law it does not have to be spelled out, but in reality, I hope the prosecution in future will disclose to the defense why this witness elects not to give evidence in court. In the relevant paper, it is said that the prosecution and the defense need to have a level playing field. I have reservations about this. The burden of proof lies with the prosecution. The defense is not required to prove their innocence. So this is not exactly a level playing field. Under the current system, the defendant is offered a certain level of protection. With the amendments to the Evidence Ordinance, the prosecution is more likely to make use of the powers brought about by the changes. In the Law Society's submission, we covered mostly our concerns relating to litigants in person. The DOJ basically said the court will make sure a fair trial is carried out, and the DOJ will also provide a certain level of support to litigants in person. But I think in the end, the court and the DOJ will not provide legal advice to the defendants. You won't tell them you will tell them what this new piece of legislation is about, but you won't tell the defendant how to exercise their right. So I hope for litigants in person, the amendments will not apply. Chair, can I go on for another minute? Please continue. Thank you. I thank members in advance for scrutinizing the relevant bill, and I ask members to refer to Annex III of the 2026 bill, or the paper on the 2026 bill. I believe some of the suggestions from before are quite useful, and also the paper, the background brief prepared by the Legislative Secretariat. Members should refer to this document to see what concerns were raised by Legislative members before. The DOJ did provide a response on the concerns raised, but I would say the answers provided do not necessarily address the concerns directly. The last paper for this item is the administration's response to the submission from the Law Society. I would like to say this I would like to touch on a specific section about multiple hearsay. If the prosecution has to rely on multiple hearsay evidence, the evidence is seriously flawed. So why are we allowing in law this option? Also, I'm not really sure how many prosecution witnesses can rely on hearsay evidence in a single case. We didn't really touch on this issue. All along, we assumed there's only one witness. So, will we have more than one prosecution witness in a single case relying on hearsay evidence? These are the points I would like to raise for members' reference. Thank you. Thank you, Chair. Thank you, representatives from the Law Society and Bar Association, for expressing your views on the amendments proposed by the administration. I also note that the DOJ said they received 15 submissions, including the submissions from the Law Society and Bar Association. And the list of papers for this item includes the submission from the Law Society of Hong Kong. I want to ask if the DOJ would like to provide a response before I open the floor to members to ask questions. Please, Dr. Howard Chung, Acting Secretary for Justice. We heard what the representatives from the Bar Association and Law Society said earlier. We would like to take this opportunity to respond to their views. Regarding protection for defendants, we do attach great importance to this in our drafting of the amendments, and as you can see in the draft bill and the paper, we have considered the Law Reform Commission's recommendations, and we have 3 tiers of safeguards in the statutory mechanism to ensure sufficient protection for defendants. So for the 3 tiers of protection, for the first tier, we have the condition of necessity and the condition of threshold reliability. For a court to accept hearsay evidence, the prosecution must reach the standard of proof of proving this beyond reasonable doubt to the court that, for example, the witness has passed away or is not suitable to give evidence due to their age, physical or mental condition, and the prosecution has taken reasonable steps and they have no other choice. And that's how they can meet the relevant condition. The court should also be satisfied that the hearsay evidence meets the threshold reliability condition. That is, there is reasonable assurance about the hearsay evidence. The prosecution cannot only for procedural convenience choose not to call a witness, but only rely on hearsay evidence. For the second tier, we propose to introduce the reliability evidence for an absent witness, and you can see in the proposed section 55(v) for admissibility of certain hearsay evidence. If the court allows the prosecution to introduce hearsay evidence, the defense can challenge the credibility of the absent witness. They can raise the criminal conviction records of the absent witness, or they can produce conflicting statements made by the witness in the past. Even though the defense cannot really challenge the witness in court, with the recommendations in this draft with this section in this draft bill, the defense can challenge the credibility of the witness so that the court or the jury can have a comprehensive assessment of the evidence. For the third tier, there is an exclusionary power available to the court. So even if the court has accepted the hearsay evidence introduction earlier, the court, as a gatekeeper, if it finds that the prejudice caused by the hearsay evidence outweighs the probative value, or having considered a case comprehensively, the chance of challenging a witness is not available will result in serious prejudice. The court can exclude the hearsay evidence that was previously accepted. The court can also exercise discretion to acquit the defendant or order a retrial. With the safeguards, it ensures the court has the power to find out about the truth while not compromising the right of a defendant to receive a fair trial. Chair, the Law Reform Commission's report said the right in the Hong Kong Bill of Rights is not an absolute right. There should be consideration of multiple factors, including the interests of the victim and the public, and accepting a piece of hearsay evidence does not constitute an infringement on the right to fair trial. So this is my response in relation to whether there are sufficient safeguards. As for mitigation or sentencing, I will ask Mr. Will-Allen Low to respond to the multiple hearsay point.
Solicitor General, Mr. Mui. Mr. Vincy Lam, representing the Hong Kong Bar Association, and Mr. Stephen Hong, representing the Law Society of Hong Kong, made some specific comments, and do allow me to succinctly respond to these comments here. Dr. Horace Cheung, the Acting Secretary for Justice, already explained the general side of things. Now, safeguards are proposed in the consultation draft enclosed in the bill. Now, about the scope of application, I'd like to take this opportunity to clarify that we have already provided a response in the paper submitted to the panel. That is, whether this proposal applies to the sentencing in criminal trials. That's point number 1 made by Ms. Lam of Hong Kong Bar Association. Now here's what our proposal goes. In relation to evidence adduced at the sentencing stage by either party, the defense and the prosecution, especially the defense, currently may adduce evidence, including hearsay evidence, as supporting grounds of the mitigation during sentencing. Our bill does not change the current approach. During mitigation in the future, the defense will still be able to do the same. There is no change. Whereas for the prosecution, if the circumstance falls within one specified in the bill, especially say if the prosecution wishes to adduce hearsay evidence as an aggravating factor, then, as I explained, there are different circumstances. The court may allow the prosecution to adduce evidence as an aggravating factor, including hearsay evidence. Now, we have adopted the LRC's recommendations. If this piece of evidence is to be adduced by the prosecution as an aggravating factor, then the prosecution must follow this new mechanism. So there is an additional requirement. I just want to make it clear that this proposal does not in any way affect the defense's rights in the mitigation stage. In fact, we put in place an additional requirement for the prosecution under the new mechanism. We have not made any revision to this mechanism in our bill. But perhaps we can improve drafting to make sure that this message comes through. The second point is this. Admission of hearsay evidence by agreement. The bill allows oral agreement to be made. And there is a concern that litigants in person may not fully appreciate the legal consequences of this kind of agreement. We fully understand where the concerns come from. First, our proposal indeed is to allow hearsay evidence to be adduced by agreement, either in writing or orally. In fact, what we mean is that oral agreement should only be made in the presence of a judge in a courtroom. Any agreement made outside the court should come in writing form, whether or not the defendant is represented. Now, the representatives of both legal professional bodies have aired their concerns, and we have carefully reviewed the arrangement. We want to make it clear that by oral agreement it should be one made in the courtroom in the presence of a judge. As for written agreement, I do believe that either party will be able to understand a written agreement thoroughly. So, for litigants in person, in order to allay the concern that they may not fully understand what an oral agreement entails and the consequences, I hope I've explained things plainly. That for defendants, especially those not legally represented, an oral agreement should only be made in front of a judge. So, for example, if a defendant agrees orally that this piece of hearsay evidence can be admitted, and in fact, it's not really easy to understand or it leads to dire consequences, and that by agreeing orally that this evidence be adduced, it will create a prejudicial effect on the defendant, then I'm sure that since this oral agreement will only be made in front of a judge, the presiding judge will not easily agree to this arrangement as well. On the contrary, if this piece of hearsay evidence is only a minor technical point, then things may be different. We have considered these circumstances, and that is why we propose that an oral agreement covers only those made in the presence of a judge. We do not want the prosecution to flex its muscle and exercise undue influence on the defendant. Now, for the third point, I'd also like to address that as well. The Law Society just now expressed their concern. That is, in the criminal proceeding, the onus of proof is on the prosecution to prove the case beyond reasonable doubt. Our proposed reform does not in any way change the onus and standard of proof. That is, the prosecution is required to prove their case beyond reasonable doubt in a criminal proceeding. That point is very clear. So if you've read our proposed bill and our papers, you will find that this point is stipulated with great clarity. According to our proposed mechanism, there is this reasonable assurance of reliability of the evidence, and that we have also proposed to meet 5 conditions, as well as the threshold of reasonable assurance of reliability, as well as another condition that is the probative value must be greater than the prejudicial effect on the defendant. So these are the conditions to be met. Unless this is an unopposed notice for evidence to be adduced. If this is opposed, you need to apply for the court's permission, and that means you need to meet these basic conditions. Now, it is not necessarily the case that after adducing hearsay evidence, the defendant must be convicted. We want to carry out this reform to address a point, and we fully agree with what Mr. Hong just now said. Now, if the person concerned in the hearsay evidence is unable to come to court as a witness, then the party should prove that, for example, either this person suffers from severe illness or this person has died and hence unable to attend court. And we are very careful, since this witness's condition may lead to the party being penalized. And we've also made reference to other mature common law jurisdictions in taking forward reform on hearsay evidence. And how they ensure the defendant's rights to a fair trial through the right to cross-examine witnesses. Reasonable grounds should be put forward, and that the evidence must reach the threshold of reasonable assurance of reliability, and that the property value must outweigh the prejudice on the defendant. So we need to strike a balance. And overall speaking, there is nothing in the interest of justice that the court must consider before, in excluding this piece of evidence. So we agree that by hearsay evidence, the witness will not be able to attend court, and we are very careful in considering the LRC's recommendations and designing the safeguards for the mechanism. In fact, according to the LRC report, reference has been made to a number of jurisdictions. And if you've read the LRC recommendations, basically we follow the New Zealand approach, which is a more cautious approach. On top of that, in drawing up the 2026 bill, we also made reference to the deliberations of this council in 2018. There was not sufficient time then for us to make further improvements. But we fully considered and consulted the views of the legal sector and legal professional bodies. We also considered carefully the views recently put forward. We've now come to consult this panel. With this proposal, we are of the view that we have struck a careful balance. So perhaps I'll stop here, Chairman. I believe that the Acting Secretary for Justice, Dr. Horace Zhang, already responded quite fully, together with my supplement, to the points made by the two representatives of the legal professional bodies.
Thank you, Acting Secretary and Solicitor General, for responding to the views of the Law Society and Bar Association. I hope with this, members have a better understanding of the background. In fact, the Chief Justice in 2001 and the Secretary for Justice then proposed changes to be made to the Evidence Ordinance, and we had the report in 2009, and in 2018 the bill was first introduced, and the bill unfortunately lapsed in that cycle. The Acting Secretary for Justice also reported on what enhancements were incorporated in this version. I also note that the administration provided a response to a submission from the Law Society of Hong Kong. All right, we have 4 members who have pressed the request to speak button. I will read out the order in which members are going to speak. Mr. Nick Chen, Mr. Dennis Leung, Professor Priscilla Leung, and Professor Alex Fan. Mr. Nick Chen will speak first. I'll assign a 4-minute time limit, questions and answers included. Thank you, Chair. I would like to support the administration's 2026 Evidence Amendment Bill. It will remove some rules that exclude hearsay evidence in criminal cases. I believe the amendments are appropriate. It does not take an across-the-board approach. It allows for fairer handling of cases. It helps the court find out more about the truth. It also allows the court to make good use of existing law and make sure the hearsay evidence meets the 2 conditions and make sure the probative value outweighs the prejudice it causes in deciding whether to accept the hearsay evidence. The court has flexibility and the discretion. It will help the court carry out a fair trial, and it will also minimize the chance of wrongful convictions. I know the Law Society in particular objects to the section about oral notice. I want to ask what is the administration's response to this, because in general, we only accept written notices. Who will speak first? Solicitor General, Mr. Llewellyn Mui. I would like to thank Mr. Nick Chen for expressing support to the proposals, believing it will implement reforms in appropriate areas. Mr. Nick Chen raised the point about the Law Society's comments on oral notices. We also observed this in the Law Society's submission. The Law Society raised a concern on whether it is appropriate to allow for oral notices. We understand this is relevant to, as Mr. Hong said earlier, when defendants do not have legal representation, whether they can handle the procedures relating to oral notices. Allow me to explain here the intent of introducing oral notices and under what circumstances it will be of use. For example, if the prosecution wants to introduce a particular piece of hearsay evidence and the defense does not agree, so there's no agreement, in accordance with the mechanism proposed, the prosecution can give notice, and based on the design of the mechanism, there is a requirement relating to the notice period, which is 28 days. And the 28-day period will start from, say, the day before the court has decided that the trial will take place 2 months later. So the 28-day period will start from the day before. So the prosecution has to give notice within the 28-day period to the defense as well as the court that they plan to introduce or adduce hearsay evidence. In that case, the notice should definitely be a written one, and there is really no way for the prosecution to justify an oral notice. And I understand the structure of the sections. If I have a wrong understanding, I hope my colleagues will support me and correct me if I'm wrong. Oral notices must be approved by the court. I didn't get it wrong, it seems. So, in general, written notices will be adopted. We want to include oral notices for special circumstances. For example, when the defense wants to adduce hearsay evidence, they might not have identified this need early on, that the need only arose during the trial. So they can flexibly, through the court's approval, give an oral notice. Going back to my earlier example, will there be special circumstances where the prosecution cannot issue a notice within a 28-day period? there is such possibility, and in design we want to allow for such possibility. But then even for the prosecution to give oral notice, approval has to be obtained from the court. So we want to preserve this option to make the mechanism more comprehensive. It does not casually allow the prosecution to adduce hearsay evidence with an oral notice. Thank you. Chair, Acting Secretary, if you allow, I will ask another colleague to supplement some information. In fact, if I refer to 55 and 2, it gives the court discretion if they want to have an oral notice to be given, they can, but the DOJ considers this to be exceptional and the court's approval will be needed when the court exercises discretion. Under what circumstances is this likely? For example, when the court wants to have flexibility that during a court hearing, the court suddenly realizes there is a need for a piece of hearsay evidence to be adduced. For example, the witness suddenly passed away, or the witness's health deteriorated significantly. Under the circumstances, a written notice cannot be given, obviously. So with these unanticipated circumstances, which is a possibility, we want to account for that. And this goes back to the intent of the bill. Due to some hard rules, we cannot offer some sort of protection. I also understand what Mr. Jonathan Mann and Mr. Llewellyn Wui talked about, how in point 10 of the paper, you talked about this actually providing protection to the defendant because the defendant may not know that they have to give written notices. It would actually be easier for them to give oral notice. Thank you. Next, Mr. Dennis Lung. Thank you, Chair. Chair, I'm not a legal professional, but I think the fact that common law allows for hearsay evidence to be introduced speaks for a lot. The administration said we had the existing system being quite rigid. If we have reliable hearsay evidence, perhaps we should accept it. We can see perhaps what other jurisdictions are doing with the hearsay evidence after it is accepted, whether it has indeed made things fairer or the mechanism more comprehensive. I think the administration needs to provide more information on this. I was an enforcement personnel before, and I think in future it is very important to provide support to frontline officers after the amendments are implemented to make the new mechanism reliable. For the general public, they don't really understand the hearsay evidence. So even if the hearsay evidence cannot be accepted now, it won't matter much to them. But in future, if hearsay evidence can be accepted, we really need to tell the general public when they are being prosecuted or when they are acting as witnesses what they have to do. So we need to do something about education. In the end, we will have many legal professionals involved. How can we make sure there is no abuse of the gray areas in that false evidence can be provided? In terms of professional training and regulation, what can the Law Society and Bar Association do to maintain our high standard of the legal profession in Hong Kong?
Who from the Department of Justice would like to respond, please? Secretary for Justice. Chair, like Mr. Leung said, we propose to change the rule of evidence regarding hearsay because of our practical experience. Very often, vulnerable witnesses are unable to attend and testify as a witness, and the trial then comes to a halt. Under the strict common law rule against hearsay, if vulnerable witnesses such as children and mentally incapacitated persons and victims who have suffered from psychological traumas are unable to testify in court because of their physical or mental condition, then the statement they made to the police earlier will be set aside as hearsay evidence and hence inadmissible in court because of this rule. And this is justice not done. Let me give you another example. Say in a residential care home, a case happened, the elderly then made a statement to the police. At the time, the elderly was able to give an account of the incident with clarity, and then because of dementia or other mental problems, the elderly person can no longer be a witness in court. And we're not doing justice because of this rule. The original intention of excluding hearsay evidence in criminal proceedings is good. The rule ensures that the evidence can be tested and the relevant witnesses can be examined and cross-examined. But as I said, there are some special circumstances that show this rule is too rigid and needs change. We seek to make an improvement through the amendment bill. As for the situation mentioned by Mr. Leung, including the point on unrepresented litigants and oral agreement, in fact, we're making reference to the existing mechanism in the Criminal Procedures Ordinance. And in fact, according to the law, the litigants in person can admit to certain facts, and in a criminal trial, this will be regarded as irrevocable. And according to the Criminal Procedures Ordinance, the admission or agreement must be made in court and must be made in writing. So, following the same logic, for this agreement made in court, albeit orally, it will become an irrevocable fact. So, we adopt the same logic in drawing up this proposal. Next, about safeguards, as mentioned by Mr. Leung, that is to avoid fake hearsay evidence from being emitted in court. we do have safeguards. The court remains the gatekeeper, and we also have professional codes for our legal professionals' compliance. We have an excellent legal system that is well known. So together with the design of safeguards in our mechanism, we'll be able to ensure justice and ensure that vulnerable groups' rights are protected. Next, Professor Priscilla Leung. Madam Chair, I was also a council member in 2018. I have this experience. It was a common wish that the law be amended, and we also made some comments back then. About this hearsay rule is strict, inflexible, and complicated. I have an open mind. I do think that changes should be made and that courts should be able to exercise discretion to admit hearsay evidence. And meanwhile, I respect the views expressed by Mr. Ng and also Mr. Hong. Now, I think the Department of Justice should explain the following. For multiple hearsay, if it becomes admissible as well, then will it raise a doubt when in criminal proceedings the burden of proof is, the onus of proof is on the prosecution to prove the case beyond reasonable doubt? I think you need to give a precise answer to the questions raised today. Another point is, as put forward by Mr. Hong, there is a question on whether the defendant will be able to cross-examine the witness if hearsay evidence is involved. I think these are important questions that should be answered. I'm not saying that the proposal does not itself address the questions, but then I listened very carefully to your response, and it seems that you have not responded thoroughly enough to the points raised. I think the Department of Justice should address the issues raised. I participated in the 2018 exercise. I don't think we should drag on our feet when it comes to the reform. Indeed, we do have injustice arising from, say, vulnerable witnesses, hearsay evidence not admitted in court. We attach great importance to fairness and due process in the common law. There should also be a sufficient chance for the defendant to be able to defend themselves. Well, this point has been raised by the Law Society, and I think that you need to elucidate the point for the benefit of the public, and you need to give a more precise answer to the question, because it hinges on everyone's right as a defendant to cross-examine the witness. This is very crucial. I just want to say to the Solicitor General that he should not beat about the bush. It is important that he answers the question. Yes, SG, specific answers to the questions on multiple hearsay and chance to cross-examine the witness. I thank Professor Priscilla Leung for asking 2 questions to follow up on the views expressed by Mr. Stephen Hong. Well, indeed, in the former part of my question, I did not specifically address the same point, and I thank Professor Priscilla Leung for reminding me about admitting hearsay evidence. There is a specific provision in the bill in this regard. Let's say if the prosecution wishes to adduce more than one piece of hearsay evidence in the same proceedings, that amounts to multiple hearsay evidence. This is one way of interpreting the term. Another meaning to the expression is that the hearsay evidence relies on the fact that is also coming from a piece of hearsay evidence. So that's another possibility, like Mr. Stephen Hong said. Now, according to the bill, for each layer of hearsay evidence or each piece of hearsay evidence, it should be scrutinized according to the stringent rules. That is, every condition must be met first, including necessity, threshold of reliability, and the probative value outweighing the prejudicial effect on the defendant. The court also acts as the final gatekeeper in granting exemptions. That's 55S in the bill. It's a long provision. The provision refers to factors that the court must consider in processing such an application. That is, in the interest of justice, if hearsay evidence already adduced is to be subsequently excluded, the court must consider the following. Say, the evidence is adduced by the prosecution, and at that stage, when the court considers an application under 55S, the prosecution at that stage should have adduced all the evidence needed to support the case against the defense. And at that stage, it's for the court to consider thoroughly whether the hearsay evidence already adduced should be excluded. And if the hearsay evidence is multiple hearsay evidence, the court must consider this extra factor. I mentioned the factors in Section 55 as the court must consider all of them. So that means the court must consider whether it's a case of multiple hearsay evidence, or in the same case, whether there is more than one piece of hearsay evidence against the defendant, and that each piece must be considered independently and separately. The court should consider these factors in deciding whether to exclude the evidence because of prejudice. The court must consider everything. For example, whether the prosecution is relying on more than one piece of hearsay evidence in making the case against the defense. All these are captured in Section 55S. All these are clear. We are confident that under this proposed mechanism, the court has clear judicial power to address the situation. Now, to answer the second point, we understand the Law Society's submission and also the concern raised by Mr. Stephen Hong earlier. This important point should be reflected in the design of this mechanism, and that is, if it's the prosecution that adduces the hearsay evidence against the defendant, that means the prosecution is relying on hearsay evidence to try to convict the defendant, and that the defendant will be deprived of a chance to cross-examine the witness in question. We fully agree that that is the case. So I invite members to refer to Section 55S again. This section sets out in detail factors to be considered by the court. These are categorically factors that the court should consider, including whether this will cause prejudice on the defendant. For example, that the defendant will not be able to cross-examine the witness. This is clearly spelled out. The 2026 bill has refined the original provision in the 2018 bill. That is, the court acts as a gatekeeper in subsequently excluding the hearsay evidence. Having considered all factors, the court is empowered to exclude hearsay evidence subsequently at that stage. That means, indeed, because of the hearsay evidence being adduced, the defendant is deprived of the chance to cross-examine the witness. We are of the view that this provision addresses fully the situation, and we fully agree that this is an important point. We have considered the matter very carefully, and that explains why it has taken us more time to take this refined approach in the reform. I hope I've addressed Mr. Leung's question and Mr. Hong's point.
Mr. Low, what you said is in paragraph 20, and the 6 factors in 55S were raised by you. Is my understanding correct? Correct. Thank you, Chair. Next, Professor Alex Fan. Thank you, Chair. I support the direction and overarching principle of the legislative amendments. I also appreciate the DOJ trying to strike a balance between having reforms made and offering protection to defendants. Is this an appropriate balance? We have differing opinions. Due to time constraints, I would like to raise 4 concerns on Section 55Q on the condition of necessity. 1B is about unfit witnesses. We have the Law Society raising some points, and the DOJ gave a response on this. But if we refer to Chapter 221 Criminal Procedure Ordinance for vulnerable witnesses, children or MIP, they will have more stringent requirements on the age. In brackets B, it only says for the age and physical or mental condition. It is quite vague. So it seems that there is some way to circumvent the existing requirements for introducing hearsay evidence. I wonder if the DOJ can impose more restrictions on this so as to allay the concerns of stakeholders. And on oral notice 55N, the court's approval is required to vary requirement regarding notices under sections 55L and 55M. And the DOJ representative said there are circumstances that were anticipated, for example, when a witness suddenly passed away. But then I am concerned because we have observed before during the testimony of a witness, when the prosecution in its examination in chief, the witness gave some testimony that was not in their original statement, and they talk about some hearsay evidence. Would that involve an application on every occasion? Does it engage the arrangements under Section 55M for approval to be given to make use of the hearsay evidence? In fact, after the notice period has expired, an application can still be made. With litigants in persons cases, it may result in serious disruptions to court proceedings. I also want to talk about multiple hearsay. In the 2009 LRC report, there are only 3 paragraphs supporting why multiple hearsay evidence should be allowed. I hope the DOJ can have more justifications on this. The report was released in November 2009, Chair, if I may, and it has been 10 odd years, and it is said the New Zealand approach is adopted. I want to ask the DOJ officers to provide more information to us after the meeting in the 10 odd years, what developments there are in New Zealand, and if there are other jurisdictions that have made changes to the use of hearsay evidence in their rules. Thank you. Dr. Horror-Strong or Mr. Llewellyn Wu. Thank you. Chair, about Section 55Q, 1B, about the witness giving evidence if the witness is unfit to give evidence. Well, I understand Professor Alex Fan's question. We have given full play to the Law Reform Commission's views. If the witness is too young or too old, that alone will not suffice. So children will not, the fact that the witness is a child will not automatically meet the condition of necessity. It has to be when the age of a witness would result in the witness being regarded as unfit. The prosecution also needs to meet certain standards. That is, it has to prove beyond reasonable doubt that the age of the witness caused their capabilities in communication and understanding to be compromised. And if they are asked to give evidence in court, they are unfit to do so. That is, they're regarded unfit to do so. It's not just about one being of a certain age will automatically satisfy the requirements for the condition of necessity. I believe in future the court will give due consideration to the different factors. For example, the young age of the witness and other factors that would meet the requirements for the condition of necessity. I hope that this answers Professor Fan's first question. On oral notice for Section 55M, I again understand Professor Fan's concern. Professor Fan understands that the approval of the court is needed. I understand what Professor Fan about the possible scenarios. My preliminary response is this. For 55N, when the court considers whether to give approval, it has to meet the 6 conditions under 55N. And these are requirements in principle. The court may exercise the power if the court is satisfied that, having regard to the nature and content of the hearsay evidence to which the notice relates, none of the parties to the proceedings is substantially prejudiced by the variation of the requirement. Two, if a written notice is in the end required, complying with the requirement is not reasonably practicable in the circumstances, or it is in the interests of justice to do so. From what I heard Professor Alex Fan say, of course he only gave some examples. The list of potential or possible scenarios is not exhaustive. But then we believe with these principles given, the court can already comprehensively consider the circumstances. About the point on multiple hearsay, apart from what I said earlier, I want to clarify something. It's not that there is a particular section in this bill that allows the adduction of hearsay evidence. I talked about earlier about 55X. It's just about how multiple hearsay say there are 2 pieces of evidence that are both hearsay and a statement is based on the other statement. Section 55X requires both statements to be admissible in evidence. So with this section, it does not mean that multiple hearsay is allowed automatically. It is about having both statements on different levels to meet the requirements. This is what Section 55X is about. It's not about allowing multiple hearsay. Either way, on the fourth question, we do note Professor Alex Fan's comments. We will try to update relevant information to talk about the practices we refer to in other jurisdictions to see if they have any updates on reforms on hearsay evidence, as well as some authorities. Once we will do it as soon as possible to provide a reply. All right, I do not see any other members wanting to speak. on this item. I can hear the representatives from the Bar Association and the Law Society do not object to the legislative amendments, and I heard members say seeking clarification on certain issues and ask for explanations. I note the DOJ's response to the submission of the Law Society, saying they are willing to scrutinize the bill's provisions further to see if there's any room for improvement. That's the end for the discussion of this item. Thank you, representatives, for attending this section.
議程項目
Next is item 4, recent development of solicitors practicing as a solicitor corporation. Let me invite the representatives to come in. We are joined by the Department of Justice, Ms. Lorraine Chan, Deputy Solicitor General of Department of Justice, and her team, as well as Vice President of the Law Society of Hong Kong, Mr. Amirali Nasir, Ms. Melissa Pang, also Chairperson of the Working Party on Solicitor Corporation Rules, Ms. Kelly Lam, Deputy SG of Law Society of Hong Kong, as well as Ms. Vicky Lee. All right, please be seated. The Secretariat issued the following papers for this item, and that is CB bracket 3195/2026 bracket 05, 6, and 7. Now, members, if you want to speak, please press the request to speak button. Let me invite Vice President of the Law Society of Hong Kong, Ms. Amirali Nasir, to speak and introduce the paper to us. Ms. Melissa Pang, Past President and Chairperson of the Working Party on Solicitor Corporation Rules, will speak later.
Panel members, thank you for giving the Law Society of Hong Kong the opportunity to update the panel on the recent developments of solicitors practicing as solicitors corporations. The Law Society has provided papers and final drafting instructions to members of the panel on 16th of March. Having said that, we are pleased to share that with you that we have provided further updates in the past week on completing all matters, which our past President and Chairperson of Working Party and Solicitors Corporation Rules, Ms. Melissa Pang, will now provide an update to the panel on the latest developments. Thank you, Melissa.
Thank you, Chair and panel members. We are now at the very final stage of the legislative process. I'm pleased to update the AJLS panel of the recent development of solicitor corporations and foreign lawyers corporations since the CJ granted approval in principle to the solicitor corporation rules, the foreign lawyers corporation rules, and the 17 pieces of subsidiary legislation of the LPO in March 2025. In August 2025, the Law Drafting Division completed the vetting of the format and styles of all 19 sets of subsidiary legislation under the LPO for implementation of solicitor corporations and foreign lawyer corporations. After the Law Society submitted the proposed consequential amendments to the LPO and the amendments to the LPO subsidiary legislation to the Policy Division for holistic review of the whole legislative exercise in May 2025. Law Society has been in close liaison with the Policy Division since last year, August to February this year. I would like to give an update on the current status on 3 aspects. The first one is the LPO amendments. The Law Society has submitted the final draft marked-up version of the LPO amendments. The drafting instructions, together with the Chinese line to take to the Policy Division on 12th of March this year, to facilitate the LPO amendments to be included in the upcoming omnibus bill, which is planned for the introduction to LegCo in July 2026. The second aspect is the LPO subsidiary legislation amendments. Law Society has also submitted to the Policy Division the final draft marked-up version of the LPO subsidiary legislation amendments in bilingual text. In addition, Law Society has submitted the conventional forms of all LPO subsidiary legislation amendments in bilingual text to CJ on 20th of March this year to seek CJ's final approval so as to commence the negative vetting procedures of LegCo as soon as possible. And thirdly, the non-LPO legislation amendments. In February 2026, the Policy Division has preliminarily identified 19 pieces of non-LPO legislation, which may require amendments arising from the implementation of solicitor corporations and foreign lawyer corporations. The Law Society has provided on 17 March this year to the Policy Division the drafting instruction of the proposed consequential amendments to all those 19 pieces of non-LPO legislation and one additional non-LPO legislation. The aim is to facilitate all those non-LPO legislation amendments to be included in the forthcoming omnibus bill in July. Law Society has conducted and completed searches of other non-LPO legislations. So apart from the proposed amendments to those non-LPO legislation mentioned above, Law Society confirms we do not find any other non-LPO legislation which require consequential amendments. So I would like to take this opportunity to thank the judiciary and the DOJ for working closely with us throughout this legislative process. As we are reaching the final stage, I look forward to all relevant principal legislation and subsidiary legislation coming into effect in the very near future. Thank you.
好，多謝律師會嘅簡介嚇。咁我而家請咧律政司副法律政策專員政策事務陳婉冰女士同我哋做一個回應。
係，多謝主席。首先感謝委員會邀請律政司出席今次嘅會議啦。較早之前律政司呢已經交咗一份文件，咁我呢度或者喺簡介咁樣介紹一下我哋律政司喺過去1年所配合香港律師會主導推動呢一個。
Let me briefly introduce the work of the Department of Justice in the past year in terms of assisting the Law Society in taking forward the Solicitor Corporation. I want to explain first and foremost that the legal profession exercises self-regulation. The Legal Practitioners Ordinance provides powers and functions of the Law Society as a regulatory body. It must perform its functions and powers independently. Section 73 empowers the Council of Law Society to make rules providing for matters, including the matters relating to overseas lawyers and foreign lawyer corporations and solicitor corporations, subject to the approval of the Chief Justice of the Court of Final Appeal. Now, regarding the legislative exercise, solicitor corporations and foreign lawyer corporations have already been incorporated into the Legal Practitioners Ordinance in 1997, but they have not come into operation. Before that, the Council of the Law Society also enacted subsidiary legislation and improved the regulatory framework for solicitor corporations and foreign lawyer corporations. So there are consequential amendments needed, including the amendments to subsidiary legislation requiring the approval of the Chief Justice, to be followed by the negative vetting procedure in this council. The role of the Department of Justice is to give advice from law drafting perspective, and that's the function of the Constitution and Policy Affairs Division. The Law Drafting Division of the Department of Justice is responsible for vetting the format of the draft rules. The Law Society, meanwhile, reviews the LPO and other relevant laws of Hong Kong to see whether other corresponding amendments are required for the implementation of the solicitor corporations and foreign lawyer corporations in Hong Kong. If need be, amendments should be put in place. Last year in March, the Law Society was informed the Department of Justice that the Chief Justice in principle approved the draft rules. That is, solicitor corporation rules, foreign lawyer corporation rules, and the consequential amendments to 17 pieces of subsidiary legislation under Cap 159, and that the Department of Justice may assist in taking forward the corresponding amendments to the principal legislation as well as subsidiarization. Now I'll explain our progress. First, in relation to LPO's amendments as well as corresponding amendments. Last year, we received a request from the Law Society. Then, in August and December last year, we provided preliminary views to Law Society. And on the 19th of December, the Department of Justice informed the Law Society that if the draft could be provided in time, we will consider including the draft rules in the upcoming Statute Law Miscellaneous Provisions Bill or Omnibus Bill. The Law Society submitted the draft to the Department of Justice on the 12th of March, and we're actively following up on that. And about consequential amendments to legislation other than the LPO, as in implementing this regime, we may need to amend other provisions other than those in the LPO. The Law Society completed the examination of the laws on the 19th of March and submitted the draft rules, and the Department of Justice is actively following up on the vetting of the proposed amendments and also subsidiary legislation. There are some 20 items of subsidiary legislation, and we're also actively liaising with different government departments and policy bureaus, as these pieces of subsidiary legislation relate to the portfolio of these policy bureaus. And we are working with these counterparts so as to take forward the amendments of these 20 pieces of subsidiary legislation as quickly as possible. Depending on the progress and the response received, and also whether there is objection to any proposed amendments, there will be progress. We are unsure of the progress at the moment, and we will do our best to include as many as possible the amendments in the upcoming Omnibus Bill. The third point is the in-principle approval given by the Chief Justice on the final version of the draft rules, including the solicitor corporation rules, foreign lawyer corporation rules, and the consequential amendments to 17 pieces of subsidiary legislation. These are not the same as amendments to the principal legislation. These are subsidiary legislation enacted upon approval by the Chief Justice under the LPO. The Department of Justice, in fact, vetted the relevant format in April and August last year. The draft has been given to the Law Society for approval by Chief Justice. Recently, Law Society reviewed the relevant subsidiary legislation and the corresponding amendments. In fact, this exercise was recently completed on the 16th of March. The latest version of the draft has been submitted to the Law Drafting Division of our department, and last Friday we issued the final draft. Law Society also submitted this draft to the Chief Justice for consideration. As for the way forward, we'll continue to work closely with the Law Society so as to facilitate the smooth implementation of the solicitor corporations and foreign lawyer corporations. All right, that's all from you. Members, I'm of the view that upon listening to the report from either the Law Society or the Department of Justice, there is indeed quite some progress in relation to the implementation of solicitor corporations and foreign lawyer corporations. And I'm sure that based on what I heard, that they will continue to work closely together. There are 4 members waiting to speak. I read out their names: Dr. Junius Ho, Nick Chan, Holden Chow, and Thomas So. I'll give each member 4 minutes, question and answer, starting with Dr. Junius Ho.
Chair, it is a long journey. This report basically is about what happened between March 2025 and March this year, but then it actually started back in 1997, and we have a long-winded journey since then to 2025. I guess we can be reasonably optimistic that this year we'll have the rules for solicitor corporations and foreign lawyer corporations included in the omnibus bill. But the DOJ representative said there are some conditions, and we have some only awaiting the approval of the Chief Justice. And I believe in Annex III we have 7 steps, and now we're already at the 6th step. And we're awaiting the approval of the Chief Justice, and we will then be able to include the amendments in the omnibus bill. Can you be clearer about the timeline for Gazettal and when the amendments will be submitted to the LegCo for negative vetting? Can you be more specific about the timeline? And when you set down the dates, you can work that out with the Chief Justice, as well as the consequential amendments. Get everything done. I just want to have them set down a date. All right, Law Society representative, do you have a planned timeline? I will also ask the DOJ to speak on this later. I believe the Law Society should have done this.
We have to be done. We're waiting for the Chief Justice and approval.
好，請律政司。
或者我回應啊，或者係回答呢個問題嘅時候咧，我諗要分。
All right, DOJ representative, let me give a response to this in 2 parts. The first part is on subsidiary legislation. The subsidiary legislation has been submitted to the Chief Justice last Friday. Now, these relate to the rules for solicitor corporations, foreign lawyer corporations, as well as 17 pieces of subsidiary legislation under the LPO. These do not need to be included in the omnibus bill because these are subsidiary legislation, and as long as we have the approval of the Chief Justice, we will be able to gazette the pieces of subsidiary legislation, and then these will undergo negative vetting. So these do not have to be included in the omnibus bill. Let me emphasize this. So this is dependent on when we'll get approval from the Chief Justice and how long it will take for the vetting process in the LegCo to be completed. So basically, the DOJ is done with this part of the exercise. As for the consequential amendments, why do we have consequential amendments? It's because when we draft the subsidiary legislation to enact these subsidiary legislation, there are consequential amendments. So we have to make changes to the principal ordinance. But we also have to make consequential amendments in ordinances other than Chapter 159, as well as some pieces of subsidiary legislation. These amendments are mostly textual. The Law Society has also realized after many years some principal ordinances requiring amendments after the handover of Hong Kong in 1997. So there are some consequential amendments submitted to them by them to us, and we will then enact relevant pieces of legislation through the omnibus bill. It does not work the same way as we had earlier for the pieces of legislation, subsidiary legislation. And we already communicated with the Law Society on this. For the consequential amendments under the LPO, we do not think there will be any significant issues. It is just dependent on our drafting progress. But for the consequential amendments to legislation under then Chapter 159, we have just received them, and it involves more than 20 ordinances. Some we cannot really confirm the timeline because these ordinances are not under the purview of ours. We have to go back to the policy bureaus to see if we can make these amendments. But as explained earlier, these are consequential amendments just to implement the operation mode of solicitor corporations. We do not anticipate a significant issue, but we have to go through the process, submit the amendments to other policy bureaus and regulatory bodies to see if we can make such amendments. And once we receive their confirmation, we will include the amendments in the omnibus bill. At this stage, we cannot really respond on behalf of other policy bureaus, but that doesn't mean we're not doing anything at this moment. We have worked with the law drafting division. We've notified them there are such consequential amendments. We want them to be prepared to hasten the drafting process. The omnibus bill does not only deal with the amendments to or relevant to the LPO changes. The bill is to implement the amendments proposed after the review of the statute law, and the LegCo has been very helpful in helping us implement these adaptive changes to the law. We want to try as much as we can include the consequential amendments relevant to the changes to LPO. We hope to submit the bill to the LegCo before the summer break. We are still working towards this target. We do want to include the amendments relevant to the solicitor corporation operation mode as we can. All right, I'll extend the meeting by 15 minutes. Next, Mr. Nick Chen. Chair, I would like to express support for the legislative amendments. I would also like to thank the administration and the Law Society for working hard in the past 30 years or so. And in fact, Mr. Lam Sen Keung, who was an ex-president, also worked hard on this. We waited long for this. The high-quality development of Hong Kong would rely on our robust legal infrastructure, and the legal sector is very important to this, especially with the Law Society that has 13,000 odd members. Before we have the operation model prevalent in the solicitor's trade that has unlimited liability, it has really impeded the development of the legal profession. With the changes, we can enhance the legal sector. With the partnership model, for solicitors to set up new firms, there has to be deep trust among the partners for them to set up a firm to take on clients. With the solicitor corporation model, I hope that it can be implemented in full. It will benefit the public as well and other sectors, because lawyers do not have to compete with each other in the firm, and there will be less disputes, I anticipate. I want to ask if the administration or the Law Society representative can respond to this. For the next stage, would you consider for solicitor corporations, their shareholders some of the shareholders not be lawyers? I think we can relax the restriction to have a bigger share or investor pool, and we can have smart money help lawyers develop further. Thank you. Do you want the Law Society representative to respond to this, or do you want the administration to respond to this? I have this question directed at the administration, but if the Law Society's representative can respond to this also, if you allow it, I would like that as well. Ms. Lorraine Chen. Thank you. The legal profession of Hong Kong implements a self-regulatory regime, so if we have some new recommendations, we will have the Law Society investigate that first. All right, Law Society representative.
Given the legislation that we have, it's very difficult to allow non-lawyers to be shareholders. But the Law Society is actively in consideration whether ABS models are the models. But I think that is in the planning stage, and I think legislative amendments would have to be made at a later stage. But it's definitely being considered by the Law Society.
好，跟住請周浩鼎副主席。
All right, Mr. Holden Chow, Deputy Chairman. Thank you, Chair. Having perused the papers, including the background brief prepared by the Legislative Secretariat, which very accurately captures the detailed discussions of the history, I have a very good idea of what happened, and the administration has indeed worked hard on this. I can see with the report on recent developments, we're at the final stage, and I appreciate that. What I observed is, in the many years of discussion, most of those in the sector are concerned whether the PIS, the insurance fees, will increase. Let me declare an interest here. I also have a law firm myself, and I believe many other members operate their own firms, and I think this is a question many legal professionals will ask. Now, we have received a clear explanation on this before, but basically with this model, we will have solicitors who are partners at a firm. There are some constraints because they bear liability. As professionals, we do have accountability, but then with the solicitor corporation model, it can allay the concerns of legal professionals, resulting in healthier development of the sector. A point made by someone earlier is of concern to me, however. With today's paper, we are still looking at the shareholders and managers being solicitors. They need to have the license to practice, and it has to be unconditional. I understand the reason behind this. If we have shareholders of law firms that are not legal professionals, I think we really need to refer to the experience of other sectors. We need to look at the pros and cons. We really have to carefully consider this. If we have solicitors be the shareholders and managers, there is a point because it is important to maintain professionalism. But then if we have non-solicitors being shareholders and managers, there are pros and cons. They may not be familiar with the sector's operations. They may not be familiar with the integrity principles, so they may compromise this in operation. I therefore think we should be prudent. But I really appreciate how we have met a milestone today. We're at this final stage of having the solicitor corporation model. I want to hear from the administration's reply on my questions.
專員。
Yes, who will take the question, please? SG? Well, same as the previous question about who should be the director. Law Society earlier conducted a study. So any change should be studied by the Law Society first, and we will carefully liaise with the Law Society on whether there will be further changes. About professional indemnity, any response from Law Society, please?
If there's going to be no effect on the PIS because the calculations will be the same for corporation as they are for limited partnership and for those, even one doesn't need to change the amendment to the ordinance as such. Because corporations would simply be the same as a limited partnership or a sole proprietor even. As far as the ownership is concerned, I think, again, that's only in the R&D stage of the Law Society. It's not in the ordinance, and it's something that will be considered when the amendment is being considered. But at the moment, no non-solicitors can be shareholders or directors of corporations.
係即係副主席現時咧，依然都係即係同頭先
Right. So just like what Mr. Nick Chan asked, because the existing rules do not allow sharing of profit with anyone who is not qualified as the legal professional. So this is not part of this legislative amendment, and things will remain status quo. Next, Mr. Thomas So. First of all, I'd like to thank the Law Society of Hong Kong for their hard work over the past 20 years. We learned how much they've done through this paper with the support of the Department of Justice recently. Now, the legal profession has waited decades for the development of the solicitor corporations. Now, in fact, the 15th five-year plan also refers to Hong Kong's position as the Legal Services and Dispute Resolution Center. We need to actively dovetail with the national development. So, as explained by the administration, we need to seek the Chief Justice's approval, and we also need to consult the policy bureaus and government departments as part of the follow-up work. Now, I'd like to know what happens if we fail to receive a response from the policy bureau. Does it mean that we need to wait for another decade? I just want to make sure that we keep this time frame reasonable. And I know that within the government, interdepartmental working groups may be set up to scrutinize matters that straddles policy bureaus. You have over 20 policy bureaus. I don't want to wait for another decade or even two. The Department of Justice may identify problems that the Law Society has not noticed before. So let's make sure there is concerted effort. I want to make sure that we can shorten the waiting time as much as possible if it's within our control. If we all work together, we can enhance efficiency to make sure that this can be implemented as quickly as possible. This is my only request. Well, from the SG's remarks, I know that the Department of Justice is more than happy to provide support and implement the proposal. Now, Mr. So's question asked about this mechanism for amendments to subsidiary legislation outside CAP 159, and that is there a mechanism to include the amendments in the omnibus bill before summer recess? Well, in fact, we do have a dedicated team to oversee all the proposed amendments to be included in the omnibus bill. And basically, all the amendments relating to this regime is handled by the dedicated team. After we received the papers from Law Society last Monday, we already asked the dedicated team to contact various policy bureaus, and we will make sure that no time is spared, and then we will actively liaise with the policy bureaus. And after we receive confirmation from them, we will proceed with drafting with the Law Drafting Division as quickly as possible. And then we will also contact the Law Society and invite them to comment on any draft available. The dedicated team would definitely be fully committed to following up on the matter. Right, thank you. Before Dr. Junius Ho speaks for the second round, I'd like to, first of all, summarize what I've heard so far from the Department of Justice and Law Society. As I understand, there are 3 groups of amendments relating to the principal legislation or subsidiary legislation. The first one relates to rules, including solicitor corporation rules, foreign lawyer corporation rules, and also consequential amendments to the subsidiary legislation under CAP 159. For this group of amendments, it was submitted to the Chief Justice for approval on the 20th of March. Now, if approval is given, then because these are amendments to subsidiary legislation, they will be gazetted, and then we will proceed to the negative vetting procedure. So much for Group A. Group B relates to amendments to CAP 159. Group C relates to amendments not related to CAP 159. As explained, there will be 20 pieces of subsidiary legislation involved. A dedicated team is following up on the matter. We are seeking replies from policy bureaus to be included in the omnibus bill. The omnibus bill does not just handle the amendments in groups B and C. It covers other amendments to the statute law. As I understand, we will keep track of the progress to make sure that they are on schedule and that there has been progress made. Dr. Junius Ho, 3 minutes. Thank you, Chair, for making a very succinct summary. Now, my question for SG is this. That is, for Group A, we have subsidiary legislation like solicitor corporation rules, foreign lawyer corporation rules, and consensual amendments to 17 subsidiary legislation. Upon CJ's approval, we can kickstart the negative vetting process immediately, right? That's for Group A? Yes. Group B relates to amendments to CAP 159. Correct. Group C, amendments to legislation other than CAP 159. As you mentioned, other policy bureaus are considering these amendments. So for Groups B and C, they don't undergo negative vetting. They will be included in the omnibus bill, right? Yes, only Group A will undergo negative vetting. Thomas So and myself need to declare interest because we were both former presidents of Law Society and we are very concerned. Apart from declaration for the conflict of interest, my question is that, say, we have the framework that's come into operation, then Law Society can proceed to the rest of the work, despite the fact that Group C and Group B are outstanding. Is that right? SG. This is a very important point. Thank you, Dr. Junius Ho. we need to amend certain provisions already enacted before 1997 in Cap 159. For example, in June 1997, there was a provision relating to a register for solicitor corporation. Now, recently, the Law Society reviewed the arrangement and believed that changes should be made. And this affects the date of operation of this provision relating to solicitor corporation. So in theory, we should wait for the corresponding amendments to principal legislation before we put the whole deal through. But what is the risk? Because in practice, let's say we call it a new business model. I don't want to drag on because for groups B and C, these amendments are relatively minor. I don't want this tiny string restricting the movement of this 1,000-pound cattle, because once we go through the negative vetting for the draft for the rules concerned, they will come into effect. Is that right? I think what SG means is that for Group A, indeed, we can go by negative vetting, but Group A's amendments are based on amendments made to the Principal Legislation Cap 159, which requires inclusion in the Omnibus Bill, and SG is suggesting that everything should be included as a package. Yes, let me give you an example. In the Principal Legislation, there is a provision on a register, but the Law Society has reviewed the provision and find it no longer necessary. So that means we need to amend this provision enacted in 1997 for the subsidiary legislation to come into operation for consistency's sake. As for the actual effective date, I believe the Law Society will go back and review the situation, and that is upon passage of the principal legislation's amendments. When should be the perfect moment for effective date? Law Society, any response?
We need the implementation of the LPO in order to give effect to the subsidiary legislation.
Right. So Law Society agrees that it's a whole package. Like SG mentioned, if the register for solicitor corporation can be dispensed with, then it will be included in the amendment to Cap 159. Is that right, SG? Please switch on her mic. Yes, it falls within Group B. So we need to pass the amendments in Group B for everything to come into effect. Right, Dr. Ho? So for Group 2 amendments, when will it come into operation? I'm not talking about Group C. What about Group B? Because it will be included in the Omnibus Bill. Let's say if your target is June this year, then if you have Group A and Group B amendments passed, there is no need to wait for Group C, right? You can take off immediately because Group C involves other items. Or are you going to include Group C in Omnibus Bill as well? In fact, you can put it aside and do it on a separate occasion. It's just a matter of wording. Once I complete the legislation amendment for Cap 159 and Group B, then I'll be reassured. If there's Group C as well, then I am anxious. How many more groups are there? I think the Law Society's understanding is that Groups B and C must take effect at the same time because Group B involves amendments to Cap 159. For example, you have this register for solicitor corporation that requires amendment if it is to be dispensed with. In Group C, it involves legislation other than Cap 159, and yes, indeed, it has to do with wording as well as substantive amendments. I think they want everything to come into operation in one go. The target is to submit this omnibus bill in July before summer break of LegCo. Right, that's the optimistic estimation. Law Society, as I understand, is that you want Groups B and C to come into effect in one go, right?
As possible.
係，唔好意思，請
Yes,
On B and C, in order for A to work, you need to have B because it's the main legislation, and C, it just leave gaps which would be dangerous. So that's why we want to be able to effect it quickly. Yeah.
好啊我要請大家去同意啊。
right, I need to invite members to further extend this meeting by 15 minutes. Any objection? No objection. Right, so the meeting will be extended by another 15 minutes. It's closing for me, Chair. To wrap up. In short, we want to synchronize groups A and B and C, and after Law Society has completed this work, is passed on to DOJ, and that it seems there is no issue with groups A and B. We're waiting for CJ's approval, and then the next step is to work on group C, right? I think today we have discussed the matter thoroughly. Would the DOJ please work harder? Today is the 23rd of March, is that right? How about targeting passage before the end of the year? We still have, say, 2 or 3 months. Please do your best to make sure that all groups are included in the omnibus bill when it is tabled in June or July.
All right, Deputy Solicitor General Dr. Junius Home mentioned ducks and cows. I hope you can make it happen. Of course, the DOJ understands the Law Society wants Group ABC amendments to come into operation together, and we want to work with that in mind. We do want to meet the target of introducing the omnibus bill before the summer break of the council, and we will, as soon as we can, submit Group B and C amendments together to the council for vetting. Any other members who would like to ask questions? If not, as I said earlier, thanks to the concerted efforts, we have made solid progress in the development of Solicitor Corporation operation model. And if we are to scrutinize the omnibus bill, we'll have the DOJ come back to tell us more. All right, any other business? Is there any other business to propose? If not, we can adjourn. Thank you.